There are more than 700,000 people across America that are illegally and unconstitutionally imprisoned on direct facial constitutional violations. Is that these states have realized that they can make tens of billions of dollars off the forced involuntary servitude of the weakest and most vulnerable in our society. And that's not a right. That's not a right with the American people when they understand the true reality of what the system is doing. The purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor or judge. It's there for the protection of the innocent. The official response from the chief legal officer of the state was, Fifth Amendment doesn't apply to us. Well, that's news to me, and I think that's news to 330 million people. If you choose and swear by oath that you will support and defend the Constitution of the United States, and then you refuse to recognize and enforce body laws, govern this nation after being informed, that is the definition of treason. I am drawing the line in the sand. I'm showing them this is what the law states.
All right, welcome back to the Tim Teaches podcast. I'm your host, Tim McCoy. Today, I'm joined by Tanawa Downing. He is a Naval Special Operations veteran and dedicated to civil rights and advocacy. He is the chief legal strategist behind the We Shall Be Free tour, a movement emphasizing equality and empowerment. The tour plans to hold 32 press conferences across state capitals and major cities over 40 days, presenting oral arguments to the United States Supreme Court. Sir, welcome to Tim Teaches. I appreciate you jumping on and can't wait to hear what you got going on.
Thank you so much for having me. And thank you for letting me speak to your audience, because this is really important stuff. So really big issue. Yeah.
So you're obviously involved in some very large advocacy right now. I haven't dug into it too much, but I kind of like to keep it that way because then I can be off the cuff and we can just go from there. So what's kind of the overall case that's going on?
So we have built now what will be the biggest civil rights case in American history. And I know that sounds, strange, especially since nobody's even heard of it. But what you got to remember is that when the people are silent and give our consent, we permit government to do things to us that they would not otherwise be able to do because we don't speak up, speak out, and demand that they do right. But when government's silent, that is an indication of guilt because government cannot refute a criminal accusation. And so today, what we're doing to get into the court to be heard, and we're at the United States Supreme Court. We've been through all the state courts. We've been all the way through the federal circuit. We're now sitting at the United States Supreme Court. We're bringing about the awareness and understanding of the people. I've been back and forth cross country 19 times over the last 18 months, telling people about these issues, raising the awareness so we can actually have, what's necessary to, force it into that jurisdiction and be heard, because this is a big problem. But we went on the indictment by a grand jury issue or the absence thereof. So, consider the Constitution of the United States, the overarching requirements. That's what makes America, America, right? Absent the Constitution, there's nothing that connects Florida to Alaska or California to Maine. There's nothing but the Constitution. That's what creates the union and all the harmony. So these states, when they joined the union, they gave up their sovereignty to subject themselves to the supremacy of the Constitution. And that's a very, very important thing to understand, because when a state chooses to enact its own alternative legislation and then substitutes it for the guarantees of the Constitution, that's going to be a problem, because that's going to lead to, of course, a breakdown of the union. And we actually today have 13 states that have enacted just that, a provision in their inferior state constitutions that function directly to the contrary of the United States Constitution. Now we have a supremacy issue. So the grand jury issue, it originates from Clause 1 of Amendment 5. I don't think that anybody would argue with me that Amendment 5 is part of the Bill of Rights. It was ratified by the people and adopted on December 15, 1791, in all intents and purposes. It is part of the Constitution. And as a result, those obligations that are there are to be preserved for the individual liberties of the people. The government must make sure that they provide those rights. If they don't, then they're acting unconstitutionally. And anytime government acts unconstitutionally, what it's going to produce is unconstitutional. So Clause 1 of Amendment 5, what it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's clear. You got to have an indictment by a grand jury before arresting someone and holding them over for a capital or infamous crime. Now, a capital crime is any crime that's punishable by death. It's pretty easy. But an infamous crime is defined by Title 18, subsection 4083, as any crime punishable by more than 1 year imprisonment in a penitentiary. So if the crime can get you more than 1 year, that would be an infamous crime. That's the very definition of it. And it's not the amount of time that you get sentenced to, it's the amount of time you can be sentenced to. Because if you get sentenced to 3 months, but you could have gotten 5 years, it would still be of infamous nature, because the arrest is what derives you can't be held to answer for that. So the arrest, and that point of the arrest, what the offense would be, would drive the infamous agent. And so our primary respondent in this case is the state of Washington.
Okay.
And so the state of Washington is it's in Bear Constitution, Article 1, Section 26 says, no grand jury shall be drawn or summoned in any county. So now we have a state that has a provision in its imperial constitution that functions directly to the contrary of the United States Constitution. And now we need to determine which law is supreme. So when the state did do that, unfortunately, and then they started going out and enforcing that particular law that was contrary to the Constitution of the United States, everything that they're doing is going to be unconstitutional, because if that arrest derives from an unconstitutional act, because the prosecuting attorney relied upon an impaired state law to abridge an obligation that they have in the Constitution, and thus not preserving the rights and liberties of the people, then what she produced is unconstitutional. In the history of the state of Washington, they've never convicted a person legally and lawfully consistent with the procedures and processes established and codified in the Constitution of the United States. That's a big deal. But it's a lot bigger, because there's 13 states across the country that do not conduct a grand jury. Then there's another 28 states that only do it partially. And what their constitutions, such as the Oklahoma State Constitution, I'm in Oklahoma right now. Oklahoma's Constitution, Article 2, Section 17 says that the prosecuting attorney can charge by information or indictment by their discretion. So the problem there is that the state of Oklahoma has permitted their prosecuting attorneys to use their discretion to decide who's going to get a constitutional right and who does not. And that's a violation of the 14th Amendment's Equal Protection Clause. This is a really, really, really big deal. There are more than 700,000 people across America that are illegally and unconstitutionally imprisoned on direct facial constitutional violations.
So just so I'm clear, like Washington is not using a grand jury to indict people, to send them. I'm in Oregon, and I was in law enforcement, and I mean, on a felony charge, we have to present it to a grand jury for it to be
constitutional.
Or yeah.
Right.
I didn't realize there were states doing this.
Yes. Washington State does not conduct a grand jury. Connecticut does not conduct a grand jury. Pennsylvania, Michigan, these are states that are acting in direct willful defiance of the laws of the United States and the will of the people. And, we can understand, by understanding the nature and foundation of the system, we can kind of understand what's driving this. Because what the grand jury is it is a neutral, unbiased decision maker that will consider the state's case, so that the state is not the person bringing the accusations, the person investigating it, the person that's judging it, and then also the person that's profiting off of the involuntary servitude of the person that they've labeled aberrant criminal behavior. And so what it is it's actually a check on prosecutorial and state power to make sure that someone is in the mix, or some entity is in the mix that will be able to make sure that the state is acting within their lawful authority. That would be the grand jury. Now, we have some other issues that we'll talk about in just a moment, and that's when you're not present in the grand jury and the unconstitutionality and illegality of that particular issue. But if the state does not conduct a grand jury, or if they've chosen to use their discretion abusively to break the law, to breach the obligation, then that is going to result in an unconstitutional act as well, because you cannot use your discretion with regard to a constitutional obligation. You can't use your discretion to break the law. No public official can do that. And so as a result, there's something known as an emolument violation, meaning that no law can be created that directs someone to break the law. And unfortunately, that's what Oklahoma did here. They create a law that permits their prosecuting attorneys to break the law under that law. And that would be a direct emolument violation. Government can't profit off of their illegal acts. And so, but the information, what happens with information is that an accuser will call up the police and say something happening. Police then will reduce that information to writing in the form of an affidavit, and then they will present it to the court, to the judge, and they'll ask the judge to issue the order to arrest based upon this information that was obtained. Mm-hmm. So it's the judge that's making the determination. He's making the determination as to whether or not there's sufficient probable cause based upon this officer's, information that he presented. Now, information as well, yeah.
Are you trying to so if the Supreme Court sides with you, are you trying to get them to go back retroactively and throw out all these cases?
They have to. Unfortunately, they have to. Now you have to understand that I'm not fighting for the prisoners, right?
For sure.
I don't know if they're innocent. That's not my job. But what I do know is they're not guilty, because guilt of process, you have to follow that process. But what is happening here is that these states have realized that they can make tens of billions of dollars off the forced involuntary servitude of the weakest and most vulnerable in our society. And that's not all right with me. That's not all right with the American people when they understand the true reality of what the system's doing. when these states choose to, create what is or is not aberrant behavior, and then they, investigate what is or is not aberrant behavior, they create an environment where the aberrant behavior can occur because of these drug task forces and other things. And then they bring the accusation against you, they judge you for it, and then they profit off of you in these for-profit state-run systems, state-run businesses for the direct benefit of the state. What the people need to understand, in particular your listeners, is that the 13th Amendment of the United States Constitution, that was the amendment that was adopted in 1865. It was right after the Civil War. It was adopted and intended to abolish slavery. Right? That was what we believe. Slavery doesn't exist anymore. But that's not true, because the 13th Amendment didn't actually say you can't have slavery. Because what it says neither slavery nor involuntary servitude shall exist except as punishment for crime. The moment we say except, it means you can't have slavery, but you got to call it justice. So what we've done here is we've actually taken something and retitled it something different, changed it from a private institution to public institution, and told the American people it doesn't exist, and it does. That's what's led to mass incarceration and the 800% increase in the prison population. That's why we have 16 times more prisoners than the next closest industrialized nation. That's why America has 5% of the world's human population, but 26% of the world's prison population, is because we are taking our countrymen, right, that are hurting, and we're not healing them from the hurt. And instead of putting them into an abuse environment where we can actually lease them out to for-profit companies such as Halliburton, Northrop Grumman, General Dynamics, Victoria's Secrets, McDonald's, and we will force them into involuntary servitude where they don't get paid a cent, but the state will collect the labor from these companies and corporations and profit off of that servitude. That's not what I think the American people want. And I think that they need to understand that if we're going to have this system profit off of the involuntary servitude, then we are the last industrialized nation to employ slavery. And
so you've been pretty successful. Obviously, you're going to the Supreme Court. Did this start in a red state, a blue state, and how's that going to affect the? It
started in Washington, which is blue. It is blue, but I haven't had good success. You don't have good success to make it to the Supreme Court. You can't.
Okay, you're just appealing. Okay.
Well, no. So we're not appealing. There's actually nothing to appeal. We're bringing an original civil action to the United States Supreme Court. We're invoking Article 3, original jurisdiction. We're removing the discretionary authority. But again, we're trying to reach a point where the timing is right, because ultimately this issue is the direct responsibility of the Supreme Court. Because what happened was that in 1887, under the Waite Court, and Chief Justice Waite was well known to be a slave sympathizer. Right? He put into place numerous rulings that undermined the Reconstruction Amendments, undermined the Union, and he did it because he wanted slavery to exist. That's well known. History well known that was what Waite's intention was. He was the court that put into place Plessy versus Ferguson. In hindsight, we can understand that was not the right ruling, but he also put into place another ruling called Hurtado versus California from 1887. And what happened there was that the state of California said, you know what, we don't want to do an indictment, so they created information. Right. And they created this whole idea of information. And they said, well, we're going to do it this way, not by indictment by grand jury. Supreme Court came out and said, oh, that's okay. State of California, you don't have to do the indictment. You can do information. That's okay. But that's not okay, because the Supreme Court of the United States, by doing that, by creating a judge-made ruling from the court and then erroneously calling it law, they removed the fundamental right of the indictment by a grand jury that's codified and enumerated in there. They did that through judicial fiat. And then they permitted the removal of the constitutional obligation. And now the state said, okay, we can do that. And then Washington, of course, enacted their provision that says, well, we just judge the Supreme Court, so we don't have to do it. So we're not going to do it.
Do you think they're just doing it as a time-saving method? That's all this boils down to, is they're just trying to get stuff processed through so much, and that's why this came into place in the first place?
So the absence of the grand jury in 1887 was so that they could bring arbitrary charges against those slaves that were pre-released. This was the buildup to the convict leasing era, because convict leasing was going on between 1880 and 1910, and it was the same thing. We had these people that were released and said, "Oh, you're no longer a slave," but then we permitted them to be able to be arrested for some arbitrary, capricious allegation, and then they would bring them in front of a justice of the peace immediately and threaten and intimidate them until they finally agreed that they were guilty, and then they would put them on train bound for the coal mine or some other business or industry that was affected by the absence of the slavery institution or the removal of it, and they were just re-enslaving the very same people and now calling them criminals instead of slaves.
Yeah, back to that one.
And that's well known. I mean, that history will tell you everything I'm saying. make sure that you understand that this is the truth. This is what happened. And we're in the same situation now because, once again, we are literally leasing out these people to these for-profit businesses, and they're not paying them anything. And, and the state is receiving compensation for the leasing out of these prisoners. But that was in 1887. That was the driver there, was that the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor or judge. It's there for the protection of the innocent. That's what it's the primary means of protecting the innocent from suffering, right? Because government can bring an accusation in the form of information, and they can arrest you for that information without validating it, because under common law, an affidavit is truth. And in fact, it's being presented as truth. That officer is saying that I present this information truthfully, factual, and correct based upon my oaths, but that officer wasn't even a witness. He collected that from someone else. So what happens with the information is that your right to confront your accuser evaporates, because you can't put that affidavit on the stand and cross-examine it. And that is well known. But there's also some other issues that are inherent to it. And that goes back to your question there, is that when you're charged by way of information, what happens is that judge is the one that determines whether or not there's probable cause to assume that the crime has been committed. They don't ask you as the accused, what happened. They simply take the information from the accuser, reduce it to writing, submit it to court. Court says, yep, this looks good. Go and arrest them. And now you're in a situation that's called an investigative detainment, which is not lawful either, because you're being deprived of certain liberties. You're being deprived of your ability to work and take care of your family and have a house and, use your vehicle and all these things that were supposed to be preserved and protected. And until you're found guilty, you're actually being deprived of them from the very beginning. So this is what's known as an irrebuttable presumption of guilt. It's an irrebuttable presumption of guilt because you're being presumed as though you're guilty based upon the mere fact of being charged with a crime. So if you're being charged with a crime and you presume that you're guilty, now you're having all of your rights taken away from you, you're put into a jail, now you're presumed guilty based upon the mere fact of being charged with a crime. And what happens with an irrebuttable presumption of guilt is that the burden of proof shifts. Normally, the prosecutor has to prove their case. They have to prove that you're guilty beyond a reasonable doubt, because you have to be treated as though you're innocent until proven guilty, but not with an irrebuttable presumption of guilt. In an irrebuttable presumption of guilt, the burden of proof shifts. And now the defendant has to prove that they're innocent, and the prosecutor doesn't have to prove that you're guilty. And this shift actually occurs, according to Blackstone, when the system focuses on speed and efficiency as opposed to established procedures and processes. This breakdown in your process occurs when they want to push them through. That was your question. And yeah, that's why they did it, is they wanted to push the numbers through. And Blackstone says that that's exactly what will happen in an irrebuttable presumption of guilt. But we live in a world where we have procedures and processes that are established and put in place, that are agreed upon, that are taken by oath that they will preserve and that they will do. And unfortunately, if we want to change, the way that we do things, then that's up to the people. It's not up to the judicial branch. That's up to the people. It's not up to the executive branch. It's up to the people, because the people reserve the right to legislate and create laws. That's Article 1, Clause 1 of the Constitution. The judicial branch has no authority to legislate. None. That's a separation of powers issue. All legislative power is vested in the Congress of the United States. The judicial branch cannot amend the Constitution in an other than lawful manner, and yet that's what they did. So the Supreme Court of the United States is going to have to address what that court did in 1887 when they created a seditious law, because sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. If you change the Constitution,
I'm sorry. Do you have a date to argue your case?
No, we don't yet. So what we're working on right now is we're collecting 500,000 criminal affidavits from actual victims across the country. People that have been arrested and either charged or convicted of, either way, because your arrest would be unconstitutional. If they move forward with an arrest without having that indictment in place, they committed a crime. It's called deprivation of rights under code of law, Title 18, subsection 242. So what we're doing is we are going around the country and we're collecting 500,000. And that was the number that I told U.S. attorneys last year when I met with them for the last time in Las Vegas, because they're ignoring this issue. You need to understand that between May and June 6th of this year, I served 37 state attorney generals, served them with notices of these criminal acts that their agents are committing. And these acts they're actually capital offenses as prescribed by law. They're punishable by death. These are serious offenses. And there's no denying the fact that there was not an indictment. And so we served the highest executive officer in 37 states so that we could make sure that they were aware. And our hope was that maybe we could find some honor. Maybe they would direct their agents to act in a lawful manner, and we could avoid what what we're ultimately having to move toward here.
Are you looking for reparations or just a change of the law?
I want our public officials to obey the will of people. I don't want them to hurt our people anymore. I don't care about the money. I don't get paid. My clients, these prisoners, they don't have money. I haven't been paid in 9 years. I operate on a donation only basis. I do that because these people need help and nobody's here to help them. And I made the decision 9 years ago that I wanted to be the best husband and father example of my children that I could. And that means that I'm going to stand up and I'm going to fight for what I love. And that is this country. And this country is nothing more than aggregated people. So if I can't stand up and fight for the people and the laws that protect those people, then I'm not much of a patriot. And so, I took it upon myself 9 years ago that this was what I needed to do because no one else was willing to do it. And so, and had to have, and because of my background in the military as well, special operations officer for 8 years, when I encounter someone warring against the Constitution of the United States, I have a statutory obligation under that oath to actually take action because that oath is perpetual. Because once you have an honorable discharge, what's called an RE-R1 discharge, once you're discharged with an honorable status, you can be fully reinstated at a point in time. They can recall you back in, which means that your oath is perpetual, it's binding, and it's self-executing. When I encounter someone that's warring against the Constitution domestically, my oath says that I do solemnly swear that I will support and defend the Constitution against all enemies, both foreign and domestic. So when I did encounter this, I had to do something. I didn't have a choice.
That's admirable of you, and everybody should support the Constitution and follow the Constitution. And I fully believe that. You're getting pushback from these states. They disagree with you.
So the only response we've gotten was from the state of Washington. They did provide a formal response. The rest of them are ignoring it. But here's the problem with the response. This came from the Attorney General, Bob Ferguson, state of Washington. He provided two responses to them. The first, he said that the Fifth Amendment doesn't apply to the state of Washington. That was his official response to the civil action and complaint that we filed against the state of Washington. This was back in 2019 when we first started the actual federal litigation. We moved through the state, now we're moving to federal. The official response from the chief legal officer of the state was the Fifth Amendment doesn't apply to us. Well, that's news to me, and I think that's news to 330 million people. But that's not really a very valid statement. And my response to him was that, the Attorney General's response is partially correct in that the Fifth Amendment doesn't apply to state because it applies to people. Rights protect people. Government has powers. So he's right. The Fifth Amendment doesn't apply to states because it applies to people. So it still is.
They need to follow the Constitution. I'm kind of curious, like Roe v. Wade was abolished and sent back to the states. Is that kind of put a hiccup in your argument?
No, so the hiccup, I have some concerns about the Trump immunity case with regard to this, but the Chevron case, if you're familiar with that, June 28th of last year. So I finished serving all the state attorney generals on June 6th. And so you need to understand Chevron wasn't really what we think it was. Because what's happening is that it's the prosecuting attorneys who are choosing which charging instrument to bring. Do I bring information? Do I bring indictment? Do I bring a presentment? Which instrument do I use? And so it's the prosecuting attorneys who work for the attorney general who's making this decision. At first glance, you would say, oh, they're the ones committing the crime. But when they choose the incorrect charging instrument because they're directed to by a state law, they're still committing that base crime, deprivation of rights under criminal law. But when they bring it to a judicial officer and they ask that judicial officer, please hold this person over, well, that judicial officer has a duty and responsibility to ensure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the prosecutor's abuse power, who relied upon an inferior state statute to deprive a person of right guaranteed by the Constitution, then he himself is depriving this person of a right under color of law. And he has now established a conspiracy to deprive rights, Title 18-241, because of his negligence in this issue. He must make sure that the proper charging instrument is in place. And so what Chevron was that we had finished serving those attorney generals on June 6th. They were all served. We provided notice. And now when you deal with a criminal conspiracy between agencies or between public officials, there's only two ways to get out of your culpability within it. One is you must notify the authorities of the crimes, which if you are the authority, that wouldn't do any good, which is why there's a second element, and that is you must notify your co-conspirators of your intent to no longer participate, but that must be done by some affirmative action. We must see that you did something to notify your co-conspirators that you will no longer participate. That's what Chevron is about. Chevron was the judicial branch saying, hey, this is a big deal. We're going to have to hear this because cat's out of the bag. But prosecutors, you have been bringing the wrong charging instrument. We've been negligent and our judges have been negligent, but we're no longer going to participate because Chevron is all about, you know what, executive branch, you don't get to create law. You don't get to look at something, say it's ambiguous, and therefore choose to bring the incorrect charging instrument through your policy and then go and enforce it. That was notifying the executive branch that you don't get to legislate. You don't have that authority because that's separation of powers. So that was the Chevron. That was the affirmative action that the judicial branch was doing to notify the co-conspirators that they are no longer going to participate, because I had already served the attorney generals and I had been producing the narrative for 7 years that, oh, it's the prosecutor's fault. Judges, you're negligent, but it's not your fault because they were doing it. But as soon as Chevron was put into place, that's when I turned around and I went and I served the same 37 state Supreme Courts. Because it's not the prosecutor's fault. It's actually the judge's fault, because the Fifth Amendment of the Constitution says no person shall be held to answer for capital N. Who makes the decision to hold someone over? That'd be the judge. So the moment the judge chooses to hold someone over, prosecutor can bring the incorrect charging instrument. But if the judge chooses to hold someone over based upon that, it's the judicial branch that's committing the crime. But in Chevron, they have passed the buck, and they've actually pointed at the executive branch and said, you guys are going to take the fault for this. And we need to find some way to be able to pit these branches of government against each other, because that's the only way we can do this. This is a monster of a case. And if we don't break up those alliances and find some way to pit them against each other, we would never be able to get anything accomplished. But when the judicial branch says, takes the narrative and takes the bait and says, oh, yeah, it's you guys' fault. We're gonna step out of this. And well, it really wasn't their fault. So now we're trying to appeal the executive branch and say, you know what, you can take the blame for this if you want, but it wasn't your fault because the judicial branch told you to do that in 1887. So what you need to do now, executive branch, is you need to notify your co-conspirators of your intent to participate, so we can actually hold the criminals that are accountable for this issue accountable for it. We want to bring together these branches of government, pit them against each other, and say, I'm not going to take the fault for this. You told us to do it. And the executive branch is going to have to do that. If they don't, then the judicial branch has already placed the blame on through Chevron. They're going to take the blame for this. And I don't know what the outcome is going to be. But what I can say is that we do have 700,000 people in prison right here in America today that are on direct facial constitutional. There's no denying that. Their arrest derived from a direct breach of a constitutional obligation, which means that everything, including the plea bargain, the trial, the sentencing, is all void because it derives from an unconstitutional act. Any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. If you commit a constitutional violation at the beginning, then everything you do after it is all tainted by the illegality of the way it was obtained. So I don't know what the people want to do about this, but this is a big deal we need to talk about, because the true issue is not about prisoners. The true issue is does the judicial branch have the authority to be able to put into place rulings and direct the people to be subject to their rulings when we were supposed to live in a world where we make the decision, where we control our destiny, not the judicial branch. They are subject to us, right? They are bound to the laws that we create because we created them in our sovereignty, and we need them to obey the will of the people, because if we don't, then we're going to have this disjointed and unequal application of laws that occurs all across the country. And this is leading to the dissolution of America. And I'm very, very concerned about the future of our country if we don't put back into place the one thing that's there and that was created to preserve the individual liberties of the people by limiting the powers of our government.
Well, I support the fight to uphold the Constitution. I think your battle is going to be a tough one. I mean, I cannot imagine any scenario where they would go back and retroactively let all these people out, right or wrong. That's not for me to decide, but
that's up to the people now. That's why I'm going on, because you're right. I don't know if these people are dangerous, and I've never, ever advocated for the release of dangerous people.
Sure.
Please don't get me wrong. I'm not an abolitionist by any stretch. We have people that are a danger to society, and we need to protect the society from them. Yeah. But the truth is that the top criminologists in the world say that only about 4% of our prison population is a danger to society. 78% of people in prison never hurt anybody but themselves, drug-related offenses. These are people that are hurting, not dangerous, right? These are people that we need to heal from the trauma that was inflicted upon them, because they're people, and people, deserve to be treated for, the damage that was caused from an absence of a mother, or they're stealing other children, or, any number of other traumatic issues that nobody cares about, because all we want to say is look at the monster and what the monster did, and let's lock that monster up. That
Yeah.
monster was created. It wasn't born.
I literally have a friend who is getting out in 3 days, and it was marijuana. He spent a year in prison, federal prison for marijuana, and it wasn't anything major, just
And
ridiculous.
that's a great example. We
Yeah.
have people that are currently serving life without parole. They will spend the rest of their life in prison on marijuana charges, and yet marijuana is legal. If this were a system that were focused on morality and right and wrong, then those people wouldn't still be there, right?
Yeah.
They wouldn't be invoking ex post facto. They would say, you know what, society said this isn't wrong, so let's get them back home, right? I think that they've already suffered and paid enough if society is out here doing it, and they're in a prison forcing an involuntary servitude for the very same thing. People have said, yeah, it's okay. I mean, the drug issue is proliferated by our government because, and it's well known from the 60s, but when our government, when it buys and sells and manufactures drugs through these drug task forces, so that it creates this criminal environment, and then the people go and break the law within that criminal environment, you go and, send them to prison. That's not really, I think, the best moral direction that our government should be going. I think that we should be, caring about the people and not creating a criminal environment, not doing these things that will intentionally, lead to criminality and aberrant behavior. I think we can have much, much better leaders of our country if our leaders choose to not be criminals. Because the issue of criminality, the way we're trying to fight it from the bottom up, where we go out and arrest the people for the crimes they commit, it's never going to work this way. It will never work, because if our country is being led by criminals, and remember, the definition of a criminal is one who transgresses the law. It doesn't matter if that law is the Constitution or that law is a state statute. If you transgress the law, that's the very definition of a criminal. So if our country is being led by criminals because they're not following the Constitution, then you can expect that our country is going to be led toward criminality, and that is going to produce environments of criminality, and that will produce a society of criminals. We are following our leaders, and we need to let our leaders know that we don't want criminals leading us. We want you to act in a lawful manner, because if you are acting unlawfully, everything you're doing, government, is unlawful, because you cannot produce a lawful outcome from your unlawful acts. This is something that they need to do. So what I'm doing more than anything else is my attack is on them. I want them to just accept their honor. And if you want to call yourself honorable, if you want to be a leader, then you have to step up and you have to lead the people. And that means you're going to lead them in a good direction, because you choose to do the right thing, not choose to do, what everyone else is doing, or not choose to ignore something that is real simply because it would be too much of a business impact to your operations. I want these people to accept the fact that today you're a criminal, but we would welcome you back from your criminality if you will lead us in a lawful direction. But if you won't, then we're going to leave you there, and you're going to be known as criminals. And I want to make sure that every single one of them is forever known as the traitors that they are. Because if you choose and swear by oath that you will support and defend the Constitution of the United States, and then you refuse to recognize and enforce the body laws governing this nation after being informed, that is the definition of treason. I mean, and so I am drawing a line in the sand, and I'm showing them this is what the law states. These are what your obligations are. You guys are clearly operating outside of it. This is a big deal. I know people need to decide, what are we going to do about this? But people need to talk about it, because we cannot break the law and then enslave people and then say, well, we are a government of laws, right? We are either a government of laws with the Constitution foundation, and that's the truth, and we can all predict our life and future because it's predictable, or we live in an arbitrary and capricious world that judges control and decide who is or is not a criminal. And I don't think that that's what the people want. So my big argument is that if in the opinion of the people of the United States, any of the provisions that guarantees the Constitution be in any particular way wrong, then let it be corrected by an amendment in the way in which the Constitution so designates. Until, if and when that time comes, every single person is entitled to every single right hereby enumerated in the Constitution, regardless of where they choose to reside within the jurisdictional United States.
Sir, that was a lot to think about, and I know that you're doing what's right in your heart, and that's what I try to do here on this channel. And I support and defend the Constitution 100%, and I feel like that's what you're trying to do. I appreciate you taking the time to break this all down for us. I am going to be following this case because I'm very interested in where it goes, and I wish you success and safe travels out there while you're spreading this message.
So the last step here is we are at Supreme Court. We're almost to 500,000 criminal affidavits. Once we reach that, then we're going to be starting this final trip around the country. And that's where we're doing 32 press conferences at 32 state capitals over the course of 40 days, ending in Washington, D.C., where there won't be a single news station in the country that won't finally be there to meet and greet me and watch me as I walk the Supreme Court to deliver oral arguments on behalf of people in the United States for the deprivation of rights, freedoms, and brought for them by this government.
How do people sign up?
So you go to my website. It's www.tanawa.com. That's TANAWAH.com. And there you can fill out the affidavits. It's available right there. We are asking for your emails. That's not because we're data harvesting. We're asking for your email addresses because we need to have a listserv so we can have ability to be able to quickly communicate with the people that are doing this. So we're permitting a downloading of the affidavit. Do not change any of the information. There's 22 blocks that are available. You don't want to change anything or add anything to it, because what we're doing is we're bringing everybody into the exact same procedural situation. Everyone will fill out the same 22 pieces of information. We don't need to know your prosecuting attorney's name, because that's an immaterial fact. The material fact is that someone portraying themselves as a prosecuting attorney did deprive you of a right that was guaranteed by the Constitution. That is the material fact. So we're trying to bring everybody together into the same procedural situation so that I can litigate these in a massive class action all together. And once one overcomes procedural situation, we will be able to provide relief to all of the individuals in the same procedural situation. So from the website, you can access all of my social media points. We've got more than 800 videos out on TikTok, little short videos that are great, very, very informational. We have YouTube, we have X, we have Rumble. It's now coming up. So we've got all the platforms. I'm fairly new because I had to build this case kind of in silo to keep myself safe. And so I did it nice and quietly. And now we're at the point where this needs to come out in public. The case is built. We've served 37 state attorney generals. We've served 37 state Supreme Courts. We've served the United States Attorney General. We've served 100 United States senators and 250 United States congressmen. We are now with the United States Supreme Court, ready to knock on their door the moment that we get funded and make this final victory lap around the country. Thank you.
All right. I can't wait to see you on the news and have a victory. All right. Thank you, sir. Appreciate you.
God bless, brother. Thank you so much.
God bless.